Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, we hope you enjoy this legal education content, and today may be the day I earn your subscription. For today's story, we're dealing with the First Amendment freedom of speech on campus as it relates to student groups hosting various speakers. In this case, we're dealing with a university who didn't like Trump and didn't like Trump's ideas and didn't like people who reminded them of Trump, or conservatives, or Republicans, or really anyone of that nature, and basically did nothing to prevent the liberals from disrupting them and hecklers vetoing and all the rest of it. In today's story, the Young Americans Foundation is suing the university for the discriminatory treatment based on viewpoint. Let's get started with this. A few months before the events in this case, the defendant, as president of the State University of New York at Birmingham, issued a statement titled, "Freedom of Speech is Fundamental to Our Mission." So right away, we know we're in for a good time. The president of the university, mere months before the events of the question, said freedom of speech is good, specifically saying, quote, "The university deplores all acts of racism and any action that limits the expression of ideas. Freedom of speech is fundamental to the core speech of the university. Academic inquiry and the exchange of ideas rests on the principle that all have the right to express their beliefs. We strongly condemn any acts that impede the expression of those beliefs and caution anyone who attempts to inhibit another's free speech. We will protect, support, and encourage the right of every individual to express concerns freely and to engage in peaceful protest. Our campus is resolute in its support for those of any race, faith, gender, sexual orientation, background, or identity." The university over here has come forward with a pretty strong free speech statement. We believe in free speech. We think it's good. We want free exchange of all ideas from everybody, all of them. And anyone who tries to stop it will bear our wrath. Are these words more than mere hollow promises? Let's read more. In contrast with this pretty strong declaration, the plaintiffs accused the university of stifling speech and contributing to political polarization while merely paying lip service to the First Amendment and violating its own core mission. No, you don't say. Accepting all the allegations in the complaint as true, which of course is the standard that we use here, the university has an unwritten policy that uses to censor, restrict, and inhibit unpopular speech. Its open policy is, we like all speech. Its hidden policy is, not so much. The speech suppression policy has been enacted, created, and put in place by the university as a policymaker. The speech policy authorizes the university, including various people, to prohibit, chill, oppose, and shut down speech in which they or other students or faculty disagree. The university apparently is a dual standard place. One standard is free speech policy, which it says free speech is good. It's a universal, unqualified boon to all who come before it. And then the university also has a secret policy, not so much for certain people. How do we know this is true? Do we have any evidence that might reflect this double treatment? Let's find out. On Thursday, November the 14th of 2019, college Republicans organized a tabling event in a high-traffic area of the university campus known as the Spine. The tabling event promoted an upcoming lecture by renowned economist and presidential advisor Dr. Laffer, entitled "Trump, Tariffs, and the Trade Wars," that college Republicans were co-hosting with the Young America Foundation on Monday, November the 18th of 2019. After nearly 3 hours without incident of tabling, at approximately 1:30 p.m., a group of college progressives confronted college Republicans over the tabling content. The college Republicans are sitting in a major thoroughfare of the campus at a table and handing out flyers about an upcoming event. And the college progressives, however, have a problem with this. They have a problem with people saying, here is an event we'd like to host. Here's who's speaking. Here's when it is. The college progressives have some thoughts they'd like to share. More, progressives. The group then attacked the college Republicans' table. The group confiscated and destroyed the event flyers and posters, which is theft, and because it's from people, robbery. Broke down and carried away their table hurled insults and obscenities at their members who were tabling, and physically assaulting one member, which is also pretty illegal, forcibly removing her hat bearing a political slogan. That's definitely robbery. The police department arrived at the scene and applied the speech suppression policy by demanding the college Republicans leave the spine while college progressives chant. Another member of college Republicans filed police reports with the police department over harassment they got from the group. So yeah, I'm seeing several criminal acts here, incidentally. We've got assault. We've got robbery, taking the hat from someone's head. That's robbery. We've got theft. That's probably also robbery, but definitely larceny. Theft of the papers, destruction of the table, destruction of property, all kinds of criminal things that are happening here from the college progressives. And surely the police department knows about this and will prosecute all the offenders. Okay. On Monday of November the 18th, Rose issued a statement regarding the tabling event. So this is the university now speaking. The College Republicans, an organization chartered by the Student Association, was joined by another group known as Turning Point that by its own choice is not chartered by the Student Association or otherwise recognized by the university. Representatives of the two groups set up tables outside the union in a reserved space without having followed proper procedures. Representatives of the union, professional staff, and of the Student Affairs group notified the tabling students that they were tabling without reservation in a space that had to be reserved and asked them to relocate. Is that what happened? The group had twice refused to move. The group's display included provocative posters with gun imagery. Ooh, provocative. It shows a gun. Ooh. This being the same day as the Saugus High School shooting. Self-evidently, from the nature of their display and refusal to cooperate and comply with procedures for reserving the speech, the group intended to be provocative. Aha! So we found out that the First Amendment protects all ideas except ones that are related to guns and ones that are related to provocative speech. Not those, but other kinds of free speech. Okay. Plaintiffs take issue with the statements characterizing the events. Yeah. Furthermore, the university admitted even though the protesters may have violated some of the rules, the university did not seek to identify or charge any of them. Not incidentally rules, but also laws. Assault, battery, robbery, larceny, destruction of property, and so forth and so on, but we're definitely not going to do anything about any of that. In between the tabling incident and the speech that the tabling incident was trying to promote, Plot, which is their name, okay? Their name is Plot. Plot stands for Progressive Leaders of Tomorrow. I am not making this up. I am not making this up. There is a group of progressive students at the university. They have a club, and their club is called Plot. Just call yourselves Plot. Why not call yourself Scheme or Conspiracy while you're at it? But we want to call ourselves Plot. Okie doke. So Plot posted a flyer to social media encouraging its members and others to disrupt the event. The Plot is not interested in freedom of speech. I love this so much because I get to say this with a proper noun and it's hilarious. Plot does not believe in freedom of speech. The Plot is against freedom of speech. Yeah. College progressives reposted the Plot's flyer to Instagram accounts. And another post, college progressives asked supporter to come out and support the Plot. To speak out against college Republicans and come out to the lecture hall and put an end to this clownery. On the day of the event, the Young America Foundation and college Republicans met with the police department and certain administrators. At the meeting, the police department told the Young American Foundation and college Republicans that the police department was aware of threats to disrupt the events by students and non-student groups alike. The police department criticized Young American Foundation and the Republicans for hosting a public as opposed to private event. Okay, so it's bad that you made it available to all comers. You should have restricted it by tickets. Okay. Additionally, the university administrators told the plaintiffs that they were unilaterally imposing two conditions. First, the university decided to increase the police presence, which is probably a very good idea, and move the event to a lecture hall with more readily available egress graphs for Dr. Laffer if needed. That sounds very reasonable. However, secondly, the university provided college progressives a lecture hall adjacent to the event and had connecting doors to the event's lecture hall. Not so reasonable. The university says, okay, we're going to move your event to a place which has better methods of egress in case someone needs to leave in an emergency. That seems very prudent. And we're going to provide other police officers. Also seems like a really good idea. These ideas seem good. Also, we're going to give the progressives the space immediately next to you that has connecting doors to your event. How did you imagine that one turning out, university? The plaintiffs requested the university announce in advance of the event that its own free speech policy required students and visitors to permit the free speech, and again sought assurances that if there's a disruption, the police department will remove the disruptors. The plaintiffs say, hey, you have a free speech policy. It's in writing. Would you mind just re-articulating that policy to remind people? But apparently they do have a problem with that. They don't want to re-articulate their policy, so they refuse to make a public statement or provide any assurances about the safety of the speech. How fun. Approximately 1 hour before the event, the plaintiffs met with the police department. At this meeting, the police department stated they were aware of college progressives and the planned disruption of Laffer event. Police told these people that if the protesters approached the podium, they would order the agents to escort the speaker out of the event in furtherance of the plot. At least 1 hour before the event was scheduled to begin, college progressives, furthering the plot, were aligned upside the lecture hall and packed into adjacent lecture hall provided by the university. Once the doors to the event were open, hundreds of students and non-students, many of them members of college progressives and the plot, flooded in and blocked the room. Many of these individuals remained seated in rows or standing in rows, side aisles, and back of the lecture hall. At the insistence of the plaintiffs, the police made one statement about the size of the crowd and the fire code and asked those standing to take seats, but took no further action when they failed. The speaker took the podium, and as everyone could have anticipated who had half a brain cell, just a few seconds later, a member of the plot stood up in the second row and began shouting accusations at the speaker. The majority of those present greeted these accusations with applause, and the disrupting student was soon handed a megaphone and urged to continue. The college Republicans who were sitting in the first row stood up and displayed free speech signs in response to disruptors, which is also the university's mission, I thought. The disrupting student spoke through the megaphone for nearly 2 minutes before police took actions to restrain him. During these events, the university directed the agents to remove the speaker from the lecture hall, and the agents complied and removed the speaker out. Heckler's veto successfully implemented. College progressives, furthering the agreed-upon plot, and their supporters continued to occupy the lecture hall, surrounding hallways, and the area outside the lecture hall for more than an hour, and the university took no actions to disperse the group. What we've seen so far is the plot thickens, and the university refuses to do anything about it. The plot has overtaken the university. The plot has overtaken the lecture hall. The plot will not be disrupted and has not been disrupted by the university. The plot has succeeded in its goals. We're thinking maybe the university may not be all that serious about that freedom of speech after all. Let's read more. That evening, Rose issued statements about the event. This is the university again speaking. The statements said, the university anticipated the event would attract demonstrators, given the challenges with tabling activities by the college Republicans last week, so it took several proactive steps to manage the event following the announcement of a planned disruption. According to the university, these steps included moving the event to a larger lecture hall, providing demonstrators the opportunity to hold their own speak out in an adjacent lecture hall, maybe not the best place for it, deploying a large number of police to maintain order, which, not so much, and telling the attendees to allow the event to go forward and reserve questions until the end. The student with the megaphone was arrested, as well as another individual who attempted to interfere with the police. The university statement further read the university was incredibly disappointed with the events that happened that night because the protesters chose instead to infringe on expressive activity of others and prevent those who wish to be heard from doing so. The university seems super concerned here because it then said the university would investigate the event and reserve the right to pursue charges. How many charges did they pursue? The very next day, the Student Association sent an email informing them that the Republicans were being suspended due to their violations, not the College Progressives, which is a proper student organization here. So College Progressives is an organization in this context. So not the College Progressives, not the plot, but the Republicans are suspended. The Student Association did not require any other groups to obtain approval for tabling, nor have they taken any action against the protesters. The Student Association said, we're suspending the Republicans, not the College Progressives, not the plot, just the Republicans. The university admitted that he and other members knew the College Progressives had encouraged students to violate the policies by disrupting the event. So the university knew they were planning on disrupting. They also conceded they had the ability to override the Student Association's action regarding suspension of the Republicans. They also promised the college Republicans and a congressman that they would discipline college progressives and notify them of that discipline. Not so much. To date, the university has not taken any action against college progressives, any students involved in the Laffer action, or the Student Association. So their investigation and promise to punish these has gone nowhere. There is also no public record or other indication of criminal proceedings, such as, for example, assault, battery, robbery, larceny, destruction of property was suppressed. Really? However, the complaint does allege the tabling event was to promote an upcoming lecture that UAF was co-hosting and towards it was contributing financially. However, the complaint does allege the tabling event was to promote an upcoming lecture that UAF was co-hosting and towards which it was contributing financially. When the college Republicans were forced to leave the event, YAF as a funder also lost its ability to promote the lecture and spread message. We've learned so far that the YAF and the college Republicans do have standing to sue. But the question is, did they sue the right people for the right things? So we have to analyze this as to all the defendants and whether or not they sued the right people, or they should sue different people. We'll go analyze whether or not the right people will be sued. Let's get started with this. Personal involvement of defendants in an alleged constitutional deprivation is a prerequisite to an award of damages under 1983. In order to prevail on Section 1983 cause of action against an individual, a plaintiff must show a tangible connection between actions of the defendant and injuries suffered. This is not particularly new. 1983 does not allow for respondeat superior liability. It doesn't allow for supervisory liability. You have to show an action that every person performed. You can't say that because the supervisor supervises, they're liable for their people they supervise. That would work in a private cause of action against dominoes, but it doesn't work in 1983. You have to show something that every defendant did. Can they show that with respect to all these defendants for all these incidents? Joining with our other circuits, this court has held there's no special rule for supervisory liability. A plaintiff must plead and prove every government official defendant through their own actions has violated the Constitution. First, the plaintiffs argue creation and enforcement of the policy alone is sufficient to satisfy the standards. The court disagrees. The plaintiffs rely on a different decision for the proposition a supervisor could be held personally responsible for creating or ensuring the continuance of a policy or practice that caused the violation. Without passing judgment on that decision, however, the court notes that the plaintiff's conclusory allegations, the state defendants were involved in creation and enforcement of the policies, cannot sustain a claim of personal involvement. Here they know the policy exists, they just don't know who exactly created it. They may have not sued the right people, and it's up to the plaintiffs to show we're suing the right people. So at this, they don't know who did it, so they can't sue those people for the speech policy. How about other stuff? As to the tabling event, the court next analyzes whether any of the defendants were personally involved in the constitutional deprivations of the tabling event. Did they do something directly with the event? The university cannot face supervisory liability. We've discussed that. Equally unpersuasive, after the incident, various university officials received statements the plaintiffs took issue with. However, it's unclear how that shows involvement with the activities themselves. The statements after the fact are not the same thing as creating the activity. So now we reach the third event, the Laffer event. The court does reach a different conclusion with the Laffer event. This time, the university was directly present at the event. In fact, before the event, the universities told the private agents hired to protect Dr. Lafferty, that they would escort them out of the room if protesters applied the podium. That is exactly what happened. They personally directed the agents to remove Dr. Lafferty. So in this situation, we do have someone from the university actually on scene making direct statements and actually directing the action. So we do know they're directly involved. So we can sue them for the Lafferty event, which in the grand scheme is, of course, the greater violation, but it doesn't necessarily end there, as we'll discuss in a moment. As for other university officials, the complaint does not sufficiently allege their individual participation to provide a basis to hold them individually accountable for the alleged event deprivations. In addition to reasons in the previous section, the plaintiffs point to university administrators who were acting under the direction of these people and their actions before the Lafferty event. The vague and conclusory allegations are insufficient to demonstrate they're personally involved in the allegation of misconduct. We have a mix of good news and bad news. The bad news is that some of these actions with respect to some of the defendants are currently not viable and have been dismissed from the complaint. But there's good news because we have other events with other people that are viable. One of the nice things here is that means we get to go to discovery. Right up to this point, we haven't been to discovery. We're on preliminary stages, motions to dismiss. No discovery has occurred. The plaintiffs don't know a lot of stuff yet because they, at this point, don't have access to, for example, internal emails or internal phone calls or anyone that anyone could testify to or questions that could be asked, for example, at depositions and so forth and so on. So now there's a cause of action that exists, which means discovery can go forward, which means that the plaintiffs can ask these people in depositions about the things. They're relevant witnesses and they can ask for records and so forth and so on. So maybe as part of discovery, they'll get information that these people were more directly involved than we know. Although they're currently dismissed from this cause of action, don't fret. They may yet reappear in this action after discovery occurs. We have our foot in the door, my friends. We have on the foot on the door. They're not out of the woods yet. But with respect to the personal stuff and the causes of action, we next have to discuss whether the First Amendment applies in these particular areas, because the university wants to argue the First Amendment doesn't apply. I know. We actually have to discuss this and whether the First Amendment applies. Let's go ahead and do that. The right to a public forum for expression of ideas is fundamental to democracy. However, the existence of this as regards to public property for the purpose of speaking there, and the standards by which limitations on such a right must be evaluated differently depending on the character at issue. So, all public property is not treated the same for the purposes of the First Amendment. Some have broader First Amendment rights than others, which is probably fair enough. Not necessarily an open license to just speak freely within the middle of the DMV, for example. So we have to consider what are the relevant First Amendment standards when it applies to this particular place. Plaintiffs contend that areas on the university's campus where the events in this action took place are a designated public forum. A designated public forum is a place that, although not traditionally open to the public, the government has made open. Speech in this designated forum is entitled to the same constitutional protection as that extended to expression in a traditional public forum, so long as the state continues to designate the forum for such use. Defendant, on the other hand, argues the areas in question are a limited public forum. A limited public forum is a subset of a designated forum, created when the university opens a non-public forum, but limits the expressive activity to certain kinds of speakers or certain kinds of events. Yes, fair enough. So the difference here is a designated forum is open to all kinds of speech. You have the traditional public forum, the quintessential example of which is a park. So that's just open, or the city street, or the city sidewalks are classic examples of traditional public forum. You don't need a special license unless you're going to have an event over a certain size or you're going to use amplifying equipment. But if you want to stand on the proverbial soapbox, so go nuts. Then you have a designated forum, which becomes the city park by designation. It wasn't before, but it is now. Then you have the limited public forum, which is open, but only for certain events and certain speeches, which this probably is most certainly a limited public forum. It's a university, it probably is somewhat limited, but critically, the limitation cannot be in the nature of a viewpoint-based restriction. It has to be viewpoint neutral. You can restrict as to subject matter, but you can't restrict as to viewpoint. So if you open it up for subjects, anyone who wants to speak on that subject from any viewpoint has to be allowed. In conducting the form analysis, we examine a variety of factors, including the form's physical characteristic and context of use, including its location and purpose. We have held that the primary factor in determining whether property owned or controlled by the government is a public form is how the locale is used. Also relevant is the government's intent in constructing the space and its need for controlling expressive activities on property as evidenced by policy or regulations, which again must be viewpoint neutral. Finally, we consider whether the property in question is part of a class of property which by history or tradition has been open and used for expressive activity. Go to example here, the public park. The court finds that based on the current factual record and for purposes of this motion, the lecture hall is a limited public forum. Even at a limited public forum, the court finds plaintiffs are able to sustain a First Amendment claim because it's plausible the state's defendants constitute viewpoint discrimination. It sure seems that way. Rose has previously stated college Republicans intended to be provocative, and state defendants were on notice that this was a planned disruption to the event. State defendants provide demonstrators a lecture hall adjacent to the event, which had connecting doors, which seems really stupid if you were expecting a disruption. Also, police department informed the doctor that the university would prefer that they cancel the event. Finally, they told private agents hired to protect the doctor they would order them to escort them out of the room if protesters approached the podium, which is exactly what happened. The university officials had clear forewarning by social media and tabling incident that protesters planned to disrupt the event. At this stage of the case, while the court recognizing that the protesters have a First Amendment right to protest, the university's officials facilitated the protest and did practically nothing to protect the plaintiff's free speech. In effect, the university's officials sanctioned the protest to denigrate into whatever suppressive content it might, which it did, which they knew about. By removing the speaker from the lecture hall instead of the unruly protesters, state defendants were not only plausibly violating this basic constitutional right, but also preventing a fruitful discussion, not the role of one of an enlightened university. You do really have to love that burn there at the end there. With we're not promoting the fundamental goals of an enlightened university. It's just a nice little slap across the face here. It's like, you're a bad university. Universities are supposed to like freedom of speech. These are the goals of an enlightened university. You have failed fundamentally to understand what a university is for. That's some nice little shade there from the court. I approve. Freedom of speech is crucial in our democracy. It is especially to be protected and promoted on college campuses, one would think, which remains the bulwark of our educational system, and where free exchange of ideas is a bedrock of education itself. Again, the court can't help to bust the university by saying you are failing at being a university. This is the place where freedom of expression is supposed to be, freedom of ideas. You suck as a university, says the district court. Very nice burn. That brings us to the end of the discussion of Young America Foundation versus Harvey Stenger. In this case, we learned that a university doesn't understand their own fundamental mission. As a university also doesn't understand their own free speech statements. And Young America Foundation had their speaker heckled, even though the university knew about it, and put the opposition literally next door with doors that connected. You can sue some of these people, not all these people. Now, as I pointed out, now that we can sue them, that means we get to go to discovery. And in discovery, we're going to learn things. We're going to learn more things. We're going to get internal memos, internal memorandums, internal phone calls. We get to depose the shit out of lots of people. Who did you talk to? Who did you speak to? What did they say? So forth and so on. How did you become aware of this? We get to depose all kinds of people. We get to depose the plot. We get to depose the college progressives. We get to depose all kinds of university officials. For the moment, some of these defendants are dismissed from the case. Sadly, I don't think for them, at least, this is the end of their story. I feel like they may come back. But until that happens, that's the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.